Business Law Review, Lease to Own or Seller's Purchase Money Mortgage? You have a contract for sale and purchase with lease provision, sometimes common known for lease to own. Pursuant to the contract, you take possession or have the right to do so, pay a down payment and the balance is payable in a monthly payments. You also have the obligation to pay real estate taxes after the year of sale. You are entitled to a deed upon payment of all installments plus interest. Unfortunately, after paying installments for a significant period of time, you defaulted. At certain point, you tendered to the seller the entire unpaid balance of the purchase price plus interest and demanded a deed. The seller refused to accept payment or give a deed and insisted that the buyer, because of his default, had forfeited further rights in the land. The trial court in H&L Land Company incorporated a case with the same fact pattern, agreed with the buyer's position, and held that the parties were in essentially the same position as if the seller held a purchase money mortgage to secure the buyer's performance of the buyer's contract obligations. The appellate court held that the vendor under a specifically enforceable installment land sale contract, who has received part of the purchase price and has given the vendee possession of the land and the benefits and burdens of ownership, is in essentially the same position as a vendor who has conveyed the legal title and taken back a purchase money mortgage, and he cannot unilaterally and summarily extinguish the vendee's equitable title upon the vendee's default. What does this mean? It means if you sign a valid buy and sale agreement with lease provision, you are probably the owner of the property, not a tenant. If you default, the seller must initiate a foreclosure proceeding to remove you if they so wish, as opposed to an eviction process. If you tender the full payment, the seller must deliver the deed. This is called right of mandatory redemption.